Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to our channel. Still on the issues of Rivers State. So a few days ago, the federal government demanded, the Attorney General in particular, demanded that the cases bordering on all files, on all cases on emergency rule in Rivers State be transferred from Port Harcourt Division of Federal High Court to Abuja Division. Of course, it didn't sit well with variants, and those who filed the suit have started reacting. And they didn't stop there. They gave us insight exactly on what will be done very soon. The fate of Fubara, even after Fubara and Yesowike have reconciled, what they will do, and they will still do regardless. And of course, they also made mention on the fairness, the precedent, antecedent precedent, and what has been taking place, what the Supreme Court says on jurisdictions, jurisprudence, and many others, and the charge given. All of that you get to hear in this very candid and open interview granted by one of the revered sons of River State, who also doubled as the former federal lawmaker and also the 2023 federal state governorship aspirant. All of this he exposed. In a moment, you're going to find out. But before we do that, please subscribe to our channel. Now, according to the news, Farah Dagogo is a former federal lawmaker and 2023 Rivers State governorship aspirant. He was also a state assembly member and is currently running a law program. In an interview, he discussed the jurisprudence of his case against President Bola Tinubu and others over the emergency rule declaration and suspension of elected officials in Rivers State. He faulted Order 49 Rule 2, upon which his case was moved from Port Harcourt to Abuja, and described it as a move by the defendant to seek procedural advantage in initiating a transfer that undermines the principle of fairness. They asked him a question. So, do you consider the transfer of your case from the Federal High Court in Port Harcourt to Abuja Division as an abuse of court process? He said, indeed, I do. The transfer constitutes a classic case of forum shopping, which the Supreme Court of Nigeria has repeatedly and unequivocally condemned. Forum shopping refers to the deliberate attempt by a litigant to move their case to a jurisdiction perceived to be more favorable even where such a court lacks jurisdiction or is not the most appropriate venue. Now, this conduct amounts to a misuse of the judicial process and is rightly considered an abuse. Cases to that effect abound. For instance, in Diga Vs Inc, which was 2010, the Supreme Court held that parties should not abandon their cases in one court only to refile it in another under the guise of a fresh suit. And this undermines the integrity of the judicial process. Now, similarly, in Ume vs INEC 2014, the Supreme Court also emphasized that legal practitioners must resist filing similar suits in different jurisdictions for the sake of strategic advantage, describing such acts as unethical and potentially sanctionable. Furthermore, in Saraki vs Kutoye 1990, the Apex Court reiterated that instituting multiple actions involving the same parties on the same subject matter in different courts is a textbook process or a textbook example of abuse of court process. Now, the referred Justice Karibi White, GSC, stated abuse of process may occur where two similar processes are used in respect of the exercise of the same right, multiplicity of actions on the same matter, even where a right exists, is regarded as an abuse. So also in Korodo Vs Okoro 1977, Supreme Court 21, the court affirmed that the parties must approach the correct forum vested with jurisdiction. Doing otherwise undermines the process. In essence, transferring this matter from Port Harcourt to Abuja in the absence of legal necessity or statutory directive is a manipulative act. It seeks to improperly influence the adjudicative process and must therefore be denounced as an abuse of court process. They asked him a question. Given that the Port Harcourt and Abuja divisions of the Federal High Court possesses concurrent jurisdiction, does this transfer promote or hinder the right to a fair hearing? He answered, Dagogo answered. He said, this question underscores a crucial issue in Nigerian jurisprudence. The scope and limits of jurisdictional parity among courts of concurrent jurisdiction. Although both divisions are part of the Federal High Court and thus possess coordinate jurisdiction, transfers between them are not automatic and must be grounded in statutory authority or permitted under procedural rules. In National Bank of Nigeria Limited versus Goldin Nigeria Limited, 1993, the Supreme Court held that courts of concurrent jurisdiction are equal and coordinate. One has no supervisory or transfer power over the other. Similarly, in Okoro vs Nigerian Army Council 2000, the Apex Court ruled that the transfer of proceedings between two federal high courts in different locations is not permissible unless specifically allowed by law. The court reinforced the position in Adosokan vs Adegorolu of 1997, Supreme Court emphasizing that judicial parity must be maintained and any assumption of superiority by one coordinate court over another is erroneous and impossible. There are, of course, exemptions, administrative or intradivisional transfers within the same court structure, that is, like between Lagos and Abuja divisions of the Federal High Court, may be permitted under Federal High Court rules. Statutory instruments such as the Federal High Court Act or at the direction of the Chief Judge, of course. Nevertheless, the transfer in question appears to lack clear justification grounded in the statute or procedural fairness. Fair hearing enshrined in Section 36 of the 1999 Constitution as amended is not merely a procedural formality, it is foundational right. Transferring a matter in circumstances that appear designed to give one party a strategic advantage inherently undermines this right. The defendant, including the President, and leaders of the National Assembly did not appear in court. Yet the case was transferred at the request of the Attorney General of the Federation. What is your assertion of this sequence of events? They asked Dagogo. Dagogo responded. He said, this sequence raises a significant concern regarding procedural fairness and potential abuse of process. In Saraki vs. Koto in 1990, 144, the Supreme Court emphasized that an abuse of process occurs when a party improperly uses the judicial process to achieve an unlawful object, including using multiple or tactical applications to frustrate proceedings. The fact here suggests precisely that the defendant, including the President and legislative leaders, failed to enter an appearance or even engage with the judicial process in Port Harcourt. Yet, a request to transfer the matter at the behest of the Attorney General was entertained and granted. In Mohammed vs. Oluwome 1990, the Supreme Court reiterated that equity aids the vigilant, not the indulgent. The doctrine of clean hands is paramount in equity. A party that fails to submit to jurisdiction but subsequently seeks procedural advantage by initiating a transfer undermines the principle of fairness. The transfer in these circumstances smacks of forum shopping and lacks the good faith required in judicial processes, as affirmed in Diga Vs Inc, Supreme Court, of course, in 2010. They asked him another question. The court has relied on Court 49 Rule 2 of the Federal High Court, which is Civil Procedure Rules 2019, for the transfer. Was this an appropriate legal basis? Dagogo answered, let's start with what Order 49 Rule 2 provides. It says the court may, sua motu, or upon application by any of the parties, transfer any suit pending before it to any other judicial division of the court where it ought to have been commenced. While the rule empowers the court or the chief judge to transfer a case for reasons of territorial appropriateness or administrative efficiency, this discretion is not unfettered. Now, the Latin phrase sua motu means on its own motion. In judicial practice, a court may raise or act on certain issues independently, including questions of jurisdiction. However, as the Supreme Court clarified in Olatubosun vs. Nisa Council 1988, even when acting sua motu, a court must hear from all parties before making a ruling to avoid infringing on the constitutional right to a fair hearing. Furthermore, opposition to the transfer is permissible under Order 48 motions and applications via a motion to vary or set aside the transfer order. Also, Section 36 of the 1999 Constitution, on the basis that the transfer prejudices the litigant's right to a fair hearing, judicial precedents such as Kikong versus the State, 1999, the court says that caution against judicial transfer, as well as in Adeniyi versus Governing Council, Yabatek, 1993, which reinforces the need for participation in decisions affecting the litigant. In summary, the procedural basis cited by the court does not suffice if it results in material prejudice, lack of consultation, or an appearance of judicial bias. Such transfers are challengeable and, where found lacking in merit or fairness, can be declared null and void. Then I asked him, in light of the ongoing reconciliation between Siminalayi Fubara and which is the suspended Rivers State Governor, and Nyesom Wike, his predecessor, what becomes of the suit if the suspension of elected officials are lifted and they are reinstated? He now answered, while political reconciliation may resolve its interpersonal or administrative issues, it does not render the legal challenge moot. This suit is an action in rem, not in personam. It is brought to test the legality of the emergency proclamation under Section 305 of the 1999 Constitution, and not to challenge the personal conduct or right of any particular individual. As I have mentioned, this action seeks to interrogate the constitutionality of suspending duly elected government officials under the guise of emergency rule. Unchecked, constitutional infractions may later crystallize into harmful precedents. If this action is not judicially examined, a future president could invoke similar powers to suspend elected government arbitrarily across the federation, thereby endangering the constitutional democracy. Therefore, the resolution of the underlying political crisis does not extinguish the jurisprudential necessity of determining whether the... Let's meet in our comment section. What's your take? Do have a nice time. God bless you. Bye.